Welcome to today's program titled Minimizing EEOC Enforcement Risk for Government Contractors, Session 4 of our Winning Combinations webinar series. All participants are in listen-only mode. However, you are welcome to submit questions throughout the presentation by using the Q&A box on the right-hand side of your screen. For those interested in obtaining CLE credit, a code will be read later in the presentation. Please write this code down as it will not be repeated and is required for the CLE credit request form. During the presentation, you will also see a slide containing a QR code that can be scanned to access and submit your request for CLE credit. You can also find a link to the request form in the connection details email you recently received. Copies of the program's recording and materials will be distributed to all attendees in the days ahead. At this time, I would like to turn it over to our first speaker, Amy Hong. Amy, you may begin.
Thanks, Sadie. And welcome everybody to part 4 of Winning Combinations. This is a series where we are pairing our government contracts practitioners with other practice groups to talk about an issue that overlaps both practice areas. So our thought behind this series is that your legal issues don't always fit neatly into one practice group, so neither should the CLE content that we are providing. So I am thrilled to be joined for this session by Andy Scroggins in our Labor and Employment group, to talk about an issue that absolutely intersects both government contracts and labor and employment, which is heightened scrutiny of EEOC enforcement for federal construction contractors. Before Andy and I get into today's content, I did want to give a quick plug for next month's content. So next month, we are going to pair our government contracts and white-collar attorneys. My colleague Erica Bakey is going to be joined by Rich Morvillo in our white-collar group to talk about informal government outreach and turning informal government outreach into effective internal investigations. Obviously, a situation that none of us want to be in, but probably a good idea to tune in just in case it ever happens to your company. You have not yet received a communication about that program, but it will be coming out in the next couple of days. And just by attending this one, you will get an email inviting you to attend that one as well. But now we can go on to the next slide and talk about today's program. Again, I said my name is Amy Hong. I co-chair our government contracts group, and so we have a full-service government contracts group here at CyFAR. I typically focus on bid protests at the GAO and Court of Federal Claims. I also handle internal investigations, government contracts, ethics and compliance, and M&A due diligence and contract novations. A couple of subspecialties I have that don't always fit generally in the general government contracts category, but I focus on federal grant compliance. So a lot of our construction contractor clients are also turning to us now for help as they might be pursuing infrastructure projects and kind of how federal grant compliance differs from federal contracting compliance. I also focus on Buy American requirements, so those domestic sourcing requirements that show up both in federal contracts as well as federal grants, particularly with the IIJA's Build America, Buy America, or BABA provisions. And then I also help companies understand small business programs and when they might be eligible for those programs and what requirements apply. And now I'm very happy to turn it over to my partner, Andy Scroggins.
Thanks, Amy. I appreciate it. I am in the Labor and Employment Group, as Amy mentioned, and within that, I'm part of our Complex Discrimination Litigation Sub-Practice Group and also an active member in the Wage and Hour Litigation Practice Group. I counsel on a whole range of employment issues. I do have some specialties. One of those is to defend class and collective actions. Often that means wage claims or disputes over classification of workers as employees versus independent contractors. And then I have an even more niche specialty, which is to defend employers in all kinds of settings against the EEOC, whether that be a typical charge investigation, a systemic charge investigation, or in litigation where I've defended more than a dozen cases in federal court when the EEOC decides to sue on behalf of a charging party. And then separate from that, I also have a lot of experience because of some litigation matters, including one that went to the Supreme Court around devising effective arbitration policies that can help employers to avoid those class and collective action claims in the first place.
So I love doing this series because, one, I always learn something about another practice area, and I also learn more about my own colleagues. So Andy, just kind of put it in perspective for some of our listeners, when would a government contractor call you?
So I would say they can call me anytime they have an employment question, and I will find the right person in CIFARS. And we have an incredible bench of experts on every topic. I'm certainly not expert on everything, but if you wanted to speak specifically with me, I would say that very, very niche specialty of EEOC investigations is it. If you get a charge and you're concerned about it, or maybe you're getting strange questions from an investigator, you're familiar with going through the charge process, but this one seems a little different and your spidey senses are going off, reach out to me and I'm happy to talk to you about that and give you some suggestions based on the vast experience I have with that agency.
Well, then it sounds like we certainly found the right person for today's webinar. So here's what we're going to be talking about. Per usual, if you've tuned in before, we have way too much content for 30 minutes, but we're going to do the best we can, and you can always send us follow-up questions after the fact. So for today, first, Andy's going to talk about EEOC applicability, kind of more generally, how it applies. Then I'm going to talk a little about how EEOC applicability and enforcement comes into play specifically for federal construction contractors, whether that's a construction contractor who is performing on a federally assisted construction project, so a grant, or a federal procurement contract, so a contract directly with a federal agency. Then Andy's going to walk through some recent enforcement examples. We're both going to give some best practices from our perspective, and then I know the portion that I am most interested in, and probably a lot of our listeners are as well, predictions for the next administration when it comes to EEOC enforcement. We can go to the next slide, and I will turn it over to Andy.
Great, thank you. Let's go on to the next slide after that. So probably if you're on this call, your employer is covered by the EEOC, is covered by Title VII. So the requirements of Title VII apply to any employer that has 15 or more employees. There are other statutes that are enforced by the EEOC, including the Age Discrimination in Employment Act, that actually only applies to employers with 20 or more employees. Also the Americans with Disabilities Act. So there are a variety of workplace civil rights statutes that the EEOC is responsible to enforce. And most of us are familiar with the kinds of protected categories that the EEOC is out there to ensure that folks are treated equally. We have them listed there. Why don't we go to the next slide? So most often, the way that a claim of discrimination arises is that an individual goes to the EEOC and they file a charge that describes why they think they were treated differently and why that relates to whatever their protected categorization may be. And the EEOC then will undertake an investigation of that charge. And those investigations sometimes will just check the box and they move on, and sometimes they really do dig in deep. Most often, an employer will submit a position statement to the EEOC, maybe some supporting exhibits. If the EEOC wants to look at them a little more closely, they might issue a request for information. They might want to interview people. They might want to do a site inspection. If they feel like they're not getting the responses that they're entitled to, they may move to subpoena that information. But most investigations are fairly routine, don't require much for an employer beyond a position statement and exhibits. If it starts getting into those other categories, then you ought to be looking at it more carefully and making sure that you're not setting yourself up for something harder down the road. The way that most charges are resolved is with a right to sue letter that's given to the charging party. And what that does is that the EEOC just says, we've looked into it, we've decided we don't want to take this up on your behalf, but you can get your own lawyer or go pro se to court and try to vindicate your claims there if you like. Sometimes the EEOC will issue what's called a cause determination, which says that they've found cause to believe that discrimination occurred. But again, most often that's accompanied with a right to sue letter that leaves the individual on their own to go to court and vindicate their rights. The EEOC will sometimes try to resolve a cause determination through what's called a conciliation agreement, which is really just an attempt to resolve things via settlement with the agency. And those can run the whole gamut from, relatively modest requirements to something that's very extensive. But if they're not able to reach a conciliation agreement, again, they might give the person a right to sue letter, or the EEOC might say, we want to litigate this case on behalf of that person. And then the EEOC will become the plaintiff in a federal court case that they file against the employer. There are about anywhere from 120 to 150 of those filed per year. That's actually down from the historical lows, but that's been the trend for the last 4 or 5 years. And those are very serious litigation matters and something you definitely want to give me a call about. Why don't we go to the next slide? And we'll turn it back over to Amy.
Yes, I will talk a little about EEOC enforcement for federal construction contractors, but before we get to enforcement, let's back up a little bit to applicability to federal construction contractors, and then I think really a primary question of what does it mean to be a federal construction contractor? Because believe it or not, a big part of my job is telling people that they are in fact federal contractors when they might not think of themselves as one. So when it comes to EEOC requirements, they're going to come in 2 forms. Fortunately, the requirements are pretty similar for both, but we're going to talk through both. The first is the requirements for federal contractors, and then the second are requirements for federal grant recipients. And we're going to kind of refer to both of those as federal construction contractors. But so what is the difference between these two? Well, a federal contract is going to be used when the federal government is directly procuring goods, or in this case, construction, for government use. So a good example, think of, GSA building building a building that's going to be an office building for federal employees, or, building something on a military base. That is construction that is done for the government's own use. And that's usually going to be done through what we call a procurement contract. A procurement contract is governed by the Federal Acquisition Regulations, or the FAR. And so you're going to see a lot of FAR clauses or requirements that are specific to an agency purchasing something. And it so happens when it comes to EEOC requirements that Executive Order 11246 and Department of Labor regulations provide for non-discrimination in employment by government contractors and subcontractors. So if you're subject to a contract that is governed by the FAR, you're going to have these EEOC requirements in by virtue of that executive order and Department of Labor regulations, and you also see these requirements set out in the FAR. Now let's pivot to federal grants, and we are seeing more questions. I've seen more questions about federal grants from construction contractors this year than I probably did in the past 5 years. And why is that? Well, all of a sudden we have a lot of infrastructure funding. And so a lot of companies that might not have ever thought of themselves as government contractors because they're never doing that first category of we're building a building for a federal government, all of a sudden might be subject to not the FAR, but to certain requirements that apply to federal grant recipients or contractors that are performing under that federal grant recipient. So federal grants are used when the government is providing funds for a project for public use. And it's hard to sometimes differentiate those because you could almost think of those federal contracts themselves as being everything the government does is sort of for public use. But a more specific example here, let's say that the Department of Transportation provides funding to the state of Virginia, and the state of Virginia is going to use that federal funding to build a bridge that the public is going to use. Well, that's not a federal contract, but it is going to be potentially a state contract, but it is more likely going to be a federal grant. The grant funds flowed through to the state of Virginia. The state of Virginia might directly give those out to recipients or might have hired a general contractor to do that. And then the contractors that are performing on that job are either going to be a subrecipient of the grant or they're going to be a contractor under the grant. They're just performing work that doesn't seem that different from private work except that they're using federal funds to do it. And those are going to be subject to requirements set out in 2 CFR Part 200. You'll see some similarities between federal contracts and federal grant requirements, but they're not exactly the same. However, when it comes to EEOC requirements, again, that same executive order and those same Department of Labor regulations also provide for non-discrimination provisions in federally assisted construction contracts. So for purposes of today's webinar, you're going to have similar enforcement concerns, you're going to have similar scrutiny, you're going to have similar requirements but the purpose of this slide was really to talk through how you could be performing two different types of work, and you might not be thinking of yourself as a federal contractor when you're performing that work, but you could be subject to this heightened scrutiny and EEOC requirements. So we can go to the next slide. So here are the EEOC requirements generally for federal contractors and grantees. Again, we could have a whole separate session that is just on kind of the nuts and bolts of these requirements, and if you have questions about how these apply, then you can come to us. But this is, you know, the bottom line up front is you've got a couple of heightened requirements set forth in the FAR or in the Department of Labor regulations that are going to apply if you have, if you qualify as a federal contractor or are performing on a federal construction project through a grant. So they're going to have certain record-keeping requirements, certain tracking requirements. There are certain posters and notifications you need to make to your employees, and then you have certain reporting that needs to happen. But again, what's more relevant for today's presentation, we can go to the next slide, is what does being a federal contractor mean for purposes of increased enforcement or scrutiny from EEOC? Well, this is not really just a prediction. This is something that the EEOC has come out and said. And if you have more questions about how this came about, Andy has a series of excellent client alerts that I can send you that really go through how we came to where we are today in terms of EEOC enforcement. So the EEOC Strategic Enforcement Plan for 2023 to 2027 has an express intent to focus on discrimination in the construction industry, particularly federally funded construction. Now, you marry that with, we have a huge influx of federal funding through the IIJA, so that's going to have even more focus on the construction industry. I went to a panel recently where there was somebody from an Inspector General's office, and she talked about kind of like there's the lightning and the thunder, and the lightning is the funding, and then the thunder is the enforcement that comes, you know, just after that lightning. So first we're seeing all of this money coming out, money on these IIJA projects. Well, that's going to be followed by enforcement. And so the EEOC is committed to collaborating with the construction industry stakeholders, to include employers, unions, and workers, to ensure fair hiring and employment practices and to prevent discrimination and harassment. And in fact, we're already starting to see some of this play out. And so I will turn it over to Andy to talk about some recent enforcement examples.
Yeah, thanks, Amy. Let's go to the next slide. So with the publication of that strategic enforcement plan, which we call the SAP, the EEOC always then takes deliberate steps to advance the things that they've said that they're going to do in terms of enforcement. And so I put up here just some of the recent complaints that have been filed. You can see two of these are just from September. And actually, we had another complaint filed that relates to the construction industry filed yesterday. It's EEOC versus CPG staffing, and I'll come back to why that's important, which challenged a decision to withdraw an offer to somebody who's going to work on a construction project as a welder because there were perception problems that maybe he was disabled and wouldn't be able to perform the job. And so you see here that the complaints that I've listed on the slide are against construction companies in general. The other one that I mentioned that was filed yesterday is against the staffing agency. But that's actually pretty common. We've seen several other examples like that where the EEOC will wind up filing suit against that temporary service agency that would have been referring the employee to the construction project. And we see a mix of that. Sometimes it's against just the staffing company, like yesterday's was. Sometimes it's against both. Sometimes it's against the construction company that used a staffing agency. What we can infer from that is that charges were filed against both, and probably in this case, the construction company resolved the charge against it. But it still got named in the complaint. It still got picked up in some of the media that I saw about it today. So when we get to best practices and things to do, I think Amy's going to talk about things you might want to have in your contracts that relate to those that you're partnering with in order to staff the work. So these are just some recent examples of the EEOC following through on what they said in that strategic enforcement plan, that they were going to target construction industry businesses for enforcement. And let's go to the next slide so we can see what some of the consequences are of that. So almost all complaints that are filed by the EEOC get resolved through a settlement, and that's done in the form of a consent decree. It has to be done publicly on the court's docket, so that's a little different than a private settlement that you're probably most familiar with when you do have to resolve these issues with employees, and they can be substantial. So a couple of the top ones here are smaller, $56,000 or $80,000. They're not nothing, right? But they're relatively small. But you can see they can also balloon into something much larger. Here's a $1.2 million settlement that was reached just earlier this year. So if the EEOC decides that you're an attractive target to them because you've got a complaint usually of harassment or discrimination based on race or sex, if they can try to expand that to include more people like we see here with the asphalt paving systems case, they're going to want to have a big settlement. They're going to want to issue a press release. They're going to want to make an example of you, and they can tie that back to say, look, we said in our strategic enforcement plan we're going after construction industry, and here's more evidence of our success in that area, and that we need to have more resources in order to continue to pursue those kinds of claims. So you can see that it sort of builds its own momentum, and a lot of their litigation is intended to send a message more broadly to an industry or a sector rather than necessarily address the worst harms that are going on out there. So if you're in the construction business, which I assume you are, if you're on this call, you've got sort of a target on your back in terms of the EEOC. Why don't we go to the next slide then, and we can go one more beyond that. And I think that Amy and I will talk about this slide jointly. So it sounds silly, but one of the most important things that you can do is have written policies about non-discrimination. But we do still run across employers that don't do a good job of writing their policies and putting them into practice. So if you do have policies that you think maybe are a little old, we have some that we can share with you, and you can take a look at that, see if maybe you need to make some modernization to those policies. And then it's also very important that those policies be communicated to your employees, that those policies are available to them. And that can vary a lot, right? It can be hard to provide written policies to people who are out on a job site all the time, but maybe you need to find a way to either give people handbooks or make sure they're in some common place that people are in on a fairly regular basis, provide it via an intranet. But you do want to be able to say to the EEOC, if you start to get in trouble, look, we have these policies, we follow these policies, we make them available to everybody. And I've got meaningful training on here. I think we've probably, especially those of us on the call who are in HR or lawyers, we sit through some tedious training, clicking the buttons on the computers. Meaningful training in the context of doing construction work might be something different. I'm a big advocate for having short messages that are part of regular meetings. So, maybe once every couple of weeks at a stand-up meeting or before a day starts on a job site, have a supervisor go over expectations for treating people, with dignity and respect and compliance with your policy. And I think that's more effective than sitting people down for an hour once a year to go through what the law requires. I think it's more about treating people with respect, and then the law and compliance of that can follow. And I think, Amy, you might have some thoughts about contract protections that people should be thinking about.
Yeah, absolutely. I mean, in this sense, EEOC enforcement is not really any different than all of the other obligations that you need to consider when you are a prime contractor and you are dealing with people lower down in the supply chain. So it's going to be no surprise to the government contracts folks on the call. You might get a government contract that is full of provisions, and then you're trying to decide whether you're going to, attempt to just pass all of those down to your subcontractors and supply chain, and maybe have a caveat of, these are going to, you have to comply with these as applicable to your certain situation. Are you going to include clauses in full text? There's really no difference between including the clause in full text versus a flow down. But the EEOC provisions, just like others in government contracts, are going to have specific requirements in terms of how they apply to subcontractors. And I will direct you to FAR Part 22 that has its own definition of subcontractor. There are something like there are many, many definitions of subcontractor within the FAR, unfortunately. But at least for purposes of these Department of Labor requirements, you've got a definition that's set out in the FAR, and you've got really specific requirements in terms of when you flow these EEOC requirements down. They've got the specific language that you should use. And your best bet in terms of protection as a prime contractor is to ensure that you are flowing these down specifically, as opposed to trying to do a general, compliance with Department of Labor laws or compliance with all federal laws. And you'd be surprised how often we try to have people having a subcontract that kind of has that broad language. Here is an area, particularly with the increased enforcement, that we recommend you going directly to the clauses that are in your contract, or if you are a federal construction contractor that is working on a federally funded construction project, so a grant, looking at the flow downs that might be required to you in 2 CFR Part 200, the Appendix 2, and making sure you're taking that express language and flowing it down to your contractors and directing that those contractors themselves flow that down when it's appropriate, so that to make sure that you're not the one holding the bag when there's an enforcement action and it turns out that nobody had properly educated their supply chain on these requirements flowing down. So I think we could all spend a lot more time on proactive measures. Again, we could have a whole other session on it, but I know that folks, I'm sure, are very curious about Andy's predictions for what's going to happen with the next administration. So let's turn to that.
Let's jump to it. Let's go to the next slide. So a lot of people don't know that there are 5 commissioners and they're appointed to terms. And so when a new president comes in, the EEOC leadership does not necessarily align to that president's party. And that's the case we face here. So the president can appoint a chair to the commission, but doesn't get to appoint the full slot of commissioners. So currently we have 3 Democrats and 1 Republican, and that will be true when the Trump administration begins. So he is anticipated to make Andrea Lucas, a current commissioner, the chair, but she'll be 1 Republican vote against 3 Democrats. And if things proceed according to the normal order, there will not be a Republican majority of commissioners until the last Democrat's term ends in July 2026, so no earlier than August 2026, assuming even that approval goes through quickly. So what does that mean? Let's go to the next slide. As the chair, assuming it's Ms. Lucas, she can control what goes up for a vote by the commission, but she doesn't have the votes to actually get her priorities through. So a lot of the things that the commission does are, basically bipartisan, and so most kind of routine requests will get approved. But part of what the EEOC often does is to kind of push the envelope of the law, and we'll probably see less of that in this new administration. Another thing that had never happened before, but President Biden did it when he took office, was to fire the general counsel of the EEOC. And it's expected that President Trump will do the same thing here. It's also possible that he will take a further unprecedented step of trying to replace some of the commissioners, which would give Commissioner Lucas a majority going forward. That's something that's never happened before. It's been whispered about. If that does happen, we will have another webinar about it. We'll get into that. So I'm just going to presume that we go forward with kind of normal order here with the transition for now. Why don't we go to the next slide? So as I mentioned, the chair decides what comes up for vote in front of the EEOC. So she doesn't have the votes, though, to get those things through. But I liked what Amy said before about this lightning and thunder idea. So the Strategic Enforcement Plan was announced in 2023. And as we've seen, they're already filing complaints based on targeting construction, for example, and other priorities. So those investigations are already in the works. They've been cooking for a couple of years now. So those cases are already in the pipeline. We might see more thunder to come down the road. And some of those might be the kinds of routine matters that Lucas will bring up for a vote with the other commissioners, because it seems like the normal working business of what the EEOC does. What she's not able to do is to change that strategic plan, because it was put in place by a vote of the commissioners. It requires a full vote of the commissioners. Her power would be more limited to issuing technical guidance, or to the extent that earlier guidance was issued by a chair, she can revoke that guidance. So she's got sort of a narrow area that she can play within here. Let's go to the next slide. I see we're running out of time, but I can go very quickly here. But in terms of what her priorities might be, Commissioner Lucas has been an outspoken person against DEI programs at employers. Her view is that there should not be any preference given based on one's sex, race, etc. So I would expect her to sort of draw back any efforts by the EEOC to push anything that might be perceived as advancing DEI programs. She has been an advocate for Title VII's protections for religion, so particularly religious accommodations, religious freedoms, but she's also approved a lot of votes and litigation and guidance around disability accommodations issues as well. And then there's strong bipartisan support for the new Pregnant Workers Fairness Act. That's had approval from all the commissioners, and I would expect her to continue to advance the EEOC's efforts to enforce that law. And why don't we go to the next slide? There we go. We sort of made it.
Everyone's been waiting for the CLE code. So you have a barcode you can scan for anybody who's dialed in. The code is SS5563. That's SS5563. Thank you all for joining us. I hope that you can tune in next month as well. Please remember that this webinar, as well as all of our past 30-minute winning combinations webinars, are available all on the SciParth website, so feel free to go back if you missed parts 1 through 3. Thank you so much, Andy, for joining us, and we will see you next month.
Thanks, Amy.